Hi, welcome to another edition of IP Somm. I'm Heather Boyd, owner and proprietor of Pillar IP, and my guest today is ALICIA Beverley, and she's the owner and proprietor, I guess, of Como IP in Australia. And we're going to talk to you today about the differences in trademark law between Canada and Australia. So, ALICIA, why don't you tell me a little bit about your agency?
Thank you so much, Heather, for having me. Como IP is a file through to registration practice. I work with a huge range of clients from small one-person businesses and startups all the way through to publicly listed companies. And so I really find that to be a real privilege to see all elements, all slices of business in Australia.
The purpose of our video vlog today is to discuss the differences or the similarities between Canada and Australia in terms of the trademark registration process.
Right.
So first off, how long is the trademark registration valid for in Australia?
Yeah, so once registered, it is valid for 10 years. And that's pretty handy, although maybe we might get the chance to talk about what that can mean for self-filers who register, forget, and then move on and then don't get the chance to renew. Something that's a really important topic for me.
So Canada in 2019 switched it. It used to be 15 years for registration.
Oh, right. Okay.
Now we're on par with virtually everybody else in the world almost.
Well, thank goodness.
With a 10-year registration period. So.
Oh, really good.
Yeah. So let's go back to the whole filing thing. So, are you a first to use or first to file country?
Yes, we're a first to use country, and that means that you will have accrued at common law some rights in the trademark if it has been used in the marketplace and it has had an outward facing life in some way, and then say, several years down the track, you decide that you'd like to file your mark. And if it turns out that someone else has filed something the same or similar in the interim, there are ways to prove that use and to hopefully secure acceptance at the stage before registration.
Okay, so and the difference between a first to use and a first to file country is rights extend from the date in a first to file country from the day you file the application versus rights in Canada and Australia as well.
Yes.
And the US. They're first to use countries. So your rights extend from the date that you started using it. But until you get registration, you have to prove that use, right?
That's right. And I think, though, that the notion that from the very first day that you use a trademark in the marketplace, that you haven't filed and gone through that process, that it has some rights. I don't feel that is the case, because really it has to accrue over time for you to really be able to prove that you have significant rights in the mark. So I would say, yes, we're first to use, but the reality is you've got to get into the filing system as soon as you possibly can to really start those rights, as you say, from that point.
Right. I mean, it sounds very familiar, very similar to I mean, if two people were to file an application at virtually the same time and when previous use, that's where it comes into play, I think, a little bit more predominantly.
You're exactly right. And I've actually seen that. Yeah, precisely.
Excellent. Okay, so next thing, how long does it take an application from the time you file it through to registration in Australia, roughly?
So a straightforward application that has no other issues will take 7.5 months. And we can be granted early acceptance within just a matter of weeks, which is really great. But
so foreign to me.
Right. But formal acceptance, so in other words, publishing in the official trademarks journal, doesn't really happen for about 5 months after the filing date, really to harmonize with that 7.5 months, because you'll have a 2-month mandatory opposition period, and 10 days after you'll go to registration. So all things being equal, 7.5 months, which is just terrific.
That's like a drop in the bucket for here.
I've started to realize that about
Yeah.
Canada.
It used to be that we could legitimately reach registration within a year if there was no complications whatsoever.
Right. Okay.
Now we're looking at 3 to 5 years because the
Yeah,
examination
that's
process,
crazy.
it
W-
is.
Why is it like that? What's the holdup, just in basic terms?
Well, in basic terms, it's the examination process. So
Okay.
it's just taking so long to be examined. We're over 25 months from application filing through to examination right now.
My goodness.
Yeah,
Wow.
it is. It's a little crazy. None of us are very happy about it, let me tell you.
I can
Um,
imagine.
but then, because the examiners are having so many difficulties with examining for distinctiveness. Uh,
Right.
I think
Okay.
they seem to be doubling down and making more work from themselves than they absolutely need to.
Actually now have two filing types, which is really great for clients who have very new trademarks where they're just absolutely in the early brand development stages.
Okay.
So that's called the TM Head Start, which I refer to as the Express, because you will hear back from IP Australia with a quick assessment. So it's not an in-depth assessment within 5 business days. And that
Eileen,
turnaround is amazing. And
how
as
is
I
that
say,
possible?
as I say, it's a quick assessment. So if you're not very knowledgeable in the trademark space, it is worth having a trademarks attorney assist you with that process, because oftentimes I have an idea of that we are going to get an adverse assessment, but I also do know that we're going to be able to get across it when we get
Yeah.
to the other side. So that's called the TM Head Start. I use it quite a lot actually for clients of mine who are in that brand development stage, because we want to have that fast feedback. Of course, I'm doing my searches and I'm giving my advice as to what I think is the case, but there's some peace of mind from having a clear report issued
Right.
by IP Australia. But ordinarily, a mark will take 3 to 5 months to achieve examination. I am finding that marks are being turned around a bit more swiftly for examination, and I think that IP Australia's investment in AI has been a big part of that. I think they're trying to find ways to really move things through the system quite swiftly.
So I saw you
Yeah.
take a sip of your water, and I know you're working now.
Yes,
What time is it there right now, Alicia?
it's just about 12:30 on Thursday afternoon. So I am having actually water in a wine glass in honor of you and the time that you are. And also I see that you have a sommelier background.
I do.
So I thought in honor of that, I'd have just some plain old H2O, but nicely done up.
And we can talk about your lovely Australian wines in a little bit, but it's now almost 8:30 in the evening here, so I
Right.
think it's fair enough for me to start with
Oh my goodness.
and I'm a straight up kind of gal, so cheers.
Cheers. I'm sure yours has a bit more punch than mine.
Oh, this is beautiful. And in true Canadian fashion, my husband won this bottle by betting on a hockey game.
That is almost too perfect.
It is. It's great. Let's talk about registrable trademarks. So, what makes a trademark registrable in Australia?
Distinctiveness is really crucial. It
Want to
needs to,
explain
sure, well, let's start with what it can't be. It shouldn't be descriptive, obviously, of the goods and or services. Anything that closely seems to describe the good or service is definitely going to get knocked back. In terms of distinctiveness, it needs to, because a trademark in Australia is a badge of origin, it needs to stand on its own and be able to indicate that it comes from a source. And therefore, in terms of the examination process, a distinctive mark will mean that it doesn't clash with another trademark, so someone else's trademark for the same or similar goods and services. So essentially, I think it boils down to the trademark really better be unique, and it should not look like someone else's, kind of, which is really what you want anyway when you're in business. You want to distinguish yourself.
Right. I mean, the ideal client coins their own trademark and puts
Exactly
their own creative expression of that in terms of artwork that goes along with it. We have a very similar definition of distinctiveness here. Trademarks are source indicators. So the distinctiveness element of that is that it distinguishes or is capable of distinguishing the goods of one from the goods of others. So
that's almost exactly how it is written here. It should be distinguishing of the goods and the services from one trader to the other.
So a client comes up to you and says that they have, they want to sell shoes and they want to call them Niker.
Right. I'd really suggest against that. And you know, it's a good point you make, because on the one hand, whilst there might be some potential, maybe negligible in that particular case, but it is true that sometimes examiners do allow marks to go forward, where the advice to your client would be, you know, I wouldn't, because even if it does, you know that you're going to have the weight of a multinational come down on you. You can just see that that's really what's going to happen next.
Right.
Of course, if a client wishes to go forward, they can experience that themselves, but that would be my advice from the outset. So yes.
I guess the recommendations to the client is not to adopt a famous mark and just modify it by adding an S or an R or plural.
Exactly.
Or, you know, those kind of things, or adding a distinctive design element to it, because no matter what, those deep pockets are coming after you.
That's right. And, you know, improvements in AI and certainly the benefits to a firm to actually pick up a fight like that, you know, financially, just in terms of fees, means that there's a lot of motivation to find those, whether or not they've been accepted or otherwise. And if they have been accepted, that they will potentially take that fight within the trademark system, but also outside of it. And if they haven't been accepted, they're very likely to take that fight outside of the system, and you know, you'll receive a legal letter in any event. It's just not worth it. Why buy yourself trouble when you can be unique?
Right. So let's bring it back to register. So there's distinctiveness. What about names? People's names, or we call them names.
Yeah, look, a person's first and last name are likely to be distinctive, but a common name in and of itself is potentially going to be an issue. And when name will be common if it shows up X amount of times in the electoral roll. At least that was the case the last time I looked at this. So that was if your name, I think, shows up. I'm hesitating to give you numbers because I think it's changed, but essentially a common name will mean that you're going to be knocked back if that is the only thing that you've used. Having said that, I have enabled clients with common names to secure registration if they had many, many years of use in the marketplace. And that is really what it takes. I mean, you're 10 plus years.
Yeah. Or it has to be that long? Because we have
it really needs to be very significant.
Yeah. We have acquired distinctiveness here in Canada, and it's got to be across Canada.
Right.
Our law states that you cannot get registration for a mark that is the name, primarily merely the name or surname of an individual who's living or who has died within the preceding 30 years, I think it is.
Right, so, that's interesting. Okay.
Yeah, so I mean, it's very, very specific about what they're saying there. But you can, obviously, and tons of people get registration. Justin Bieber has registration, and Ian Dion has registration for their names in association with specific goods and services, because they have become so well known that people understand that they're using it as a brand to sell promotional products or other goods and services.
Right.
So, But we generally counsel our clients that 3 to 5 years of extensive use across Canada should be sufficient to be able to prove use. Do you have language reciprocity rights? So if someone were to file, I mean, sorry, maybe this is a very broad question. Is
Right.
Australia a bilingual country, or is it unilingual?
No, we're definitely a multicultural country,
Yes, yes.
for sure. But in terms of officially, no, absolutely not.
So
No.
official language is English only, so that's why all translation. So you probably wouldn't have the reciprocity. But we can Canada, being a multi-language official, we have 2 official languages, English and
Yes.
French. So if you file a trademark in English, you're presumably protected for the identical translation in French. Now, that's all in theory. Practically
Right.
speaking, there could be 6 different types of translations. So you still have to police both the French and the English side of things. So do you have to use your trademark in Australia to get registration?
No, you don't. And you can have an intention to use it for really the length of the 10-year registration. You do have the opportunity to say to IP Australia, hey, this trademark is not in use. And then IP Australia will take that application and then put the onus on the owner of the trademark to prove that the mark is actually in use. There is a statutory period that they have to prove that it was in use within 3 years and 1 month and a day prior to the application.
Okay.
And unfortunately, the threshold is very low. So
it's the
having
same.
mentioned it once is fine.
Yeah.
Sorry.
I mean, it's virtually the same in Canada. We've
Yes.
got what we call a cancellation proceeding under
Right. Okay.
45. So that you have to use a trademark in Canada, or you're vulnerable to cancellation proceedings.
Yes,
But those
absolutely.
cancellation proceedings cannot start until the mark has been registered for a minimum of 3 years.
Right. Okay.
So
Well,
it
that's
doesn't
right.
become vulnerable until 3 years.
Yeah. I mean, when you say, do you have to use it? You don't have to use it necessarily, but if you haven't used it, it does make it vulnerable to being removed for non-use.
Maybe we can talk a little bit about the differences in costs. I mean, there's a misnomer out there that when you say IP, trademarks, patents, industrial designs, copyright, particularly in Canada, that these are really too expensive for anyone.
Yeah.
The reality is, if you're making money, you need to protect
Mm,
your idea, your trademark, your
that's right.
reputation, that kind of thing. And if you can't afford to protect it through
Yeah.
registration, then why are you in business? Like if you
Yes,
can
that's
make enough
right.
money to cover this, then
And I think it's about the prioritizing of trademarks as being a fundamental foundational right for the business and also a valuable asset for the business going forward.
and I think
I
that
think that
that that nails it. I don't think a lot of people that aren't trademark or IP savvy, I don't think they understand what the value is. Um,
yes, that's right.
when I talk to my clients, the first thing that I tell them, like new people coming to me, they're starting their brand or whatever, and they go, oh, well, maybe after we've made a whole bunch of money, we'll come back and register. And I said, if you plan on going outside of the Ottawa region with your brand or your business, then you need to register now. And they're like,
Yeah.
it'll be fine, kind of thing. But the reality is, they're putting their reputation, their identity out into a virtual space the minute that
Yes.
they start advertising their brand.
Yeah.
What happens on the dark interweb is that people steal
Mm-hmm.
things. Hey, that's a
Yes,
really good idea. I think I'll just pick it up and I'm going to use it in 2 counties over. And, then
exactly.
they register it because
Mm-hmm.
they want to. Yeah. So to new business relationships, to new friendships. And thank you so much, Alicia, for joining me. Cheers.
Such a pleasure and cheers. Thank you so much.
So thanks for joining me on IP Somm. If you like what you saw here, please like, share, comment below, and subscribe to our YouTube channel. Remember, we're not providing legal advice here. We're just talking IP and sipping on something. And for me, it's Canadian whiskey. Cheers.
Thanks, Heather.